Well, let me thank the chairman for holding this hearing. I also want to thank my colleague, Senator Reed, who's at the Armed Services Committee, for his tireless work to pursue legislation that we are working on together. He and I have been working to codify and clarify our laws regarding insider trading since 2015 when we introduced the Stop Illegal Insider Trading Act. I'm glad to be able to continue that work today with a discussion of our new bill, the Insider Trading Prohibition Act. And I believe this is common sense legislation that will provide much needed clarity and regulatory stability, as well as protections for investors. So let me turn to my questions. I believe that everyone is more or less in agreement that insider trading is unfair. And that, to me, is reason enough to clearly and explicitly ban the practice. However, I also want to push back on the idea that it is a victimless crime. One of the reasons I believe it's important to codify our laws against insider trading is that the practice has tangible negative effects on the economy. Professor Jackson, can you talk about some of the negative consequences of insider trading on markets and shareholders and the public at large?
Absolutely, Senator. Thank you. Our inability to enforce the insider trading laws and the limits of the judge-made doctrine that we have has very real costs for ordinary Americans. What it means is that when they enter our markets, they can't be as sure as they should be, sir, that they're going to be on a level playing field, but instead that they might be trading against individuals who have better information than they do for reasons unrelated to the actual underlying value of the stock, but instead because those individuals are in a privileged position, for example, in the senior management of the company. Those are very real costs that ordinary families face. And when they try to plan for their retirement or education, we should do better in making clear to them that when they put that money in the market, like my parents did years ago, they're going to be on a level playing field rather than trading against somebody who knows more than they do simply because they happen to work at the company.
Yeah, I think insider trading can increase market volatility and certainly reduce the confidence in markets and companies at the expense of shareholders, which is why I think it's important that we act. Let me ask you, one of the goals of the Insider Trading Prohibition Act is to clarify certain conflicts that have arisen in the courts. One such clarification is that this legislation makes it unlawful to trade securities based on information that the trader knows or has reason to know was wrongfully obtained, regardless of whether the trader knows whether a source breached a fiduciary duty and/or if they derived any personal benefit. Can you explain to the committee what led to the court conflict over personal benefits and why this clarification is important?
Absolutely, Senator. What happened in the courts is they were trying to understand when a tipper inside a company gives information to a trader, why she did that. And what they did was use the personal benefit approach as a way to understand whether she was personally getting something by giving away this information. And while in theory that sounds like a good idea, Senator, the problem is in practice, as I was suggesting earlier, the way financial markets work is that people don't trade information for bags of cash. No, they trade information, as Professor Coffey has explained, in relationships, conversations, trading favors, et cetera. That's the way information passes in our markets today. And if we make the government prove that they handed over cash in order to give up their secrets, what that really means is that we won't be able to bring those cases. And as you pointed out, Senator, what that means is that ordinary Americans can't be sure they're getting a fair deal when they invest in our markets.
Okay. So I raised this point. Thank you for your answer and your insights, because it exemplifies what the legislation is all about. It's about making sure that the law is clear, that it resolves existing ambiguities and covers the full range of practices that constitute insider trading. If someone knowingly trades on inside information, it shouldn't matter whether that person shared the information, violated a duty or received a benefit. And finally, one question Congress has been grappling with is how to fit digital assets into existing financial and regulatory frameworks. Though our bill doesn't directly deal with digital assets, it's important to consider how these assets might interact with insider trading regulations. Dr. Coffey, what concerns, if any, do you have regarding insider trading in the digital.
Well, right now, of course, the securities laws do not apply to cryptocurrency as such. That does apply to certain initial public offerings of cryptocurrencies. It's a funny distinction. But I do think that it's a wild west out there in terms of cryptocurrencies. We don't know what's going on, but it's extremely volatile and people are making or losing billions. And I don't want the small investor getting into that until the market is cleaned up and the West becomes a somewhat tamer place. Okay? That's the world of cryptocurrencies. I just want to emphasize what the professor, what my colleague was saying a minute ago. The Bahara report is not for making strict liability. It's not for making insider trading very easy to prosecute. It is instead saying using only the personal benefit standard is under-inclusive. Properly counseled by good lawyers, hedge funds can avoid making a payment or promising a payment, and then they are immune if you use the personal benefit standard. What you should instead use, and I think this is a representative body, the Bahara Commission, said we should instead use a wrongfulness standard. Did the parties know they were behaving wrongfully? When you tell someone else, we just got word Dell's going to reduce its earnings by 50%, it'll be announced the day after tomorrow, and the two hedge funds trade like wild and make, in the case of the Newman case, something like $72 million in that one day, I think that's the kind of behavior that I can say shows wrongfulness. And if you want to add a little bit more to the statute to make that wrongfulness requirement even clearer, we are not suggesting strict liability. We're suggesting if you behave wrongfully but don't pay a clear bribe, you can still be held liable. If you don't say that, you created a royal road for hedge funds to get very rich and behave very badly.
Thank you. Senator Tillis.